Hi students, this is a quick video that I've decided to put together with one of the tutors who's currently teaching into LLB 103, Chris Turnbull. And the reason for making this very quick vodcast is to try and expose you to somebody who's actually doing conciliations in practice. So one of the things that I mentioned in the week 6 vodcasts is the idea that conciliation as a process is very poorly defined, and it looks quite different depending upon the area in which it's being practiced. And so I wanted to have or set up a quick interview with Chris to try and understand his practical experience of the way the conciliation process works. So Chris, as a starting point, can you tell us what's your job outside of tutoring, and how does that engage you with the process of conciliation?
All right. Well, James, I'm appointed as a Registrar of the Family Court of Australia and Federal Circuit Court of Australia. Now, in its Family Law Division. Now, the Family Court of Australia deals with the most complex family law matters, but most family law matters are dealt with by the Federal Circuit Court of Australia. And that's where most of my work is. You're allocated responsibilities in one court or the other. I'm appointed under the certain provisions of the Family Law Act with special delegated statutory powers.
Sure. So you actually, in your role, you are doing conciliations.
Indeed. My job covers a number of areas, including divorces and improving agreements and some other administrative work, but most of my job actually is doing conciliation conference in matrimonial and de facto property settlement matters.
Okay, so when parties want to conciliate, how does that process start? Do they have to approach the federal court in some capacity and start to file an action, or can they just go straight to a conciliation?
No, they can't go straight to a conciliation conference. There is, when you file an application, you have a first court date in front of a judge or a registrar, depending on which court you're in.
Yep.
Most people nowadays are sent off to a private mediation process.
Yep.
But if there's a relatively modest property pool, or there are additional issues that might make it difficult for people to go to private mediation, for example, most of their property is superannuation or something like that, then they'll be sent to a conciliation conference. The court will make orders to attend a conciliation conference, and there's usually a bunch of associated orders made about valuation of items in dispute and disclosure of documents, and that all has to occur before the conciliation conference takes place.
So just to make sure I've understood that correctly, does that mean that these federal court judges have the power to send parties to either mediation or conciliation, depending upon what they think is appropriate?
Indeed. They have broad powers to send parties to any sort of dispute resolution process that they consider appropriate,
Yep.
except for arbitration where the consent of all parties is required.
Right, okay. So what does a usual conciliation process look like then? In the family court, is it usually a face-to-face thing, or is it done over the telephone?
It can be either or, but most of them are done face-to-face or in the same location at
Yep.
the same time. We do quite a lot of shuttle conferences because many of our matters have issues raised of family violence or imbalance of power.
Can you just explain what you mean by a shuttle conference?
Oh, I see. The shuttle conference will be with one solicitor and a party in one room, one solicitor and a party in the other room, and I'll move between the rooms. Alternatively, I can bring both the lawyers together in the one room, have a discussion with them, and then have continual private meetings with each of the parties with their lawyers as they go.
Do you try and get the parties together in the same room where it's possible to do so?
Yeah, wherever it's possible to do so, but because there's no formal intake process, there's a bit of very careful checking to begin with. Is there a domestic or family violence order in place? How comfortable do they feel in the same room as the other party? If I'm there and regulating what people have to say, does that make a difference to them?
Yeah.
And where I can, I'll get people in the same room with the lawyers.
Given that issues like personal safety and potential histories of domestic violence are at play between parties in family disputes, why don't they have an intake process for conciliations?
That's a very interesting question. I suspect it's a bit of a historical thing that once upon a time everybody got a conciliation conference because the Family Law Act actually says before a court hears a matrimonial property dispute, everyone should go to a conciliation conference. Then in more recent times, with a more user pays model, they've dispensed with that, and because of funding issues. So on the other hand, parties are made aware of the ability to make safety plans for attendance at court, and there's a lot of information on that in the website, and a lot of people are legally represented, so that ameliorates it to some extent.
Sure.
I also have the benefit of the court file before the conciliation conference. So I've read the material. I know whether or not there are family violence orders in place. And so while there's no formal intake process, there are ways and means in which I can assess suitability.
Okay. One final question then. In the lectures for this unit, we've talked about conciliation as being an evaluative or an advisory process, whereas a process like mediation, for example, can be facilitative or evaluative depending upon the type of model that you're using. Do you think in practice it's fair to say that conciliations are evaluative processes?
Indeed. It is permissible in a conciliation environment to evaluate the cases of both the parties. There are some key differences really between the model that I'm involved in and facilitative models. The first is, of course, that the issues are confined to the legal issues within the scope of the dispute. So without going into a long history of family law, there are only really 4 issues in a matrimonial property case, and those are the issues that we discuss with the parties, not what they think their issues are.
Sure.
And so once we've worked through those issues in an opening statement type format, then at some point in the negotiation process, I will express a view, and it's permissible for a conciliator to express a view about the likely result.
That would have to mean then that for anybody who is conciliating in that environment, you've got quite a good knowledge as to family law and how it does apply to that particular dispute.
Yes. Well, in my case, I can tell people I've got a PhD in matrimonial property. So that establishes my line expertise in the subject matter. But the nature of the jurisdiction is such that there will be a wide variability of outcomes. So there's a lot of doubt creation. So there's a lot of, well, this could happen, or something dramatically different could happen depending on how the evidence falls. So there is some very strong reality testing with parties about what level of evidence they have in support of a particular point, what their solicitor thinks in terms of results, and how confident that solicitor is in terms of the outcome. And we'll evaluate the particular cases. And if I think a lawyer's got their law wrong, I'll say so. And quite robustly.
Right, folks, that's everything that we wanted to discuss. Just a very quick introduction as to the way conciliation is happening in practice in a family law context. And thanks to Chris Turnbull, one of our excellent tutors in the unit, for having a quick chat.
Thanks, everyone.